Good morning, council. Welcome to the Tuesday morning docket of the November 30th, 2021 of the Kansas Court of Appeals. We have one case on our docket today. I'm Judge Anthony Powell, and I'll be the presiding judge this morning, which means that I'll be trying to keep some time this morning. With me are two very distinguished judges. We have Judge Gordon Atchison and one of our senior judges, Judge Richard Walker, with us on the panel today. I'm going to call the case of Isaac Saiz versus State of Kansas, case number 123612. And may I have the appearances of counsel, please? Starting with the appellant.
May it please the court, Richard May, appearing on behalf of the petitioner, Isaac Saiz.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present, ready for argument.
You counsel, I know, are familiar with the drill. We have 15 minutes aside this morning. Mr. Ney, how much time would you like for a rebuttal?
I'd like to reserve 3 minutes if I could, Your Honor.
You may proceed.
Thank you. May it please the court. First, I'd like to thank the court for allowing this case to be continued for oral argument to accommodate my schedule. I do appreciate it very much. This is a case of a young man, 16 years old, Isaac Saiz, who was sentenced when he was 16 to a hard 40 plus 36 and a half years consecutive to that hard 40 case. Effectively, Isaac, if all the planets align for him and he gets parole on the hard 40 after 40 years immediately, even with good time, he'd be looking at a sentence that would be completed on his 87th birthday or sometime during his 87th birthday. I calculate that perhaps 2069. A significant sentence, and our position is this is a virtual life sentence. The court in our 1507 and a Miller claim, the district court found, well, it really wasn't a life sentence. And the state argues that issue as well. Obviously, people can live longer than 87 years old, which is how old Isaac would be, again, if the planets align for him. But most people don't live that long. I don't know what we're calling a life sentence if it's not something of this nature. I read about a woman, the oldest woman just dying, 124. Is that going to be our cutoff? Could we have a 200-year sentence and say, well, that's not a life without parole? I question that. And I think the Kansas Supreme Court in the Brown case questioned that a life sentence, a sentence of this sort, would not gain scrutiny by the courts under Miller. If we look at the Brown case, the Kansas Supreme Court in 2014 said that a hard 20 sentence for a juvenile was not unconstitutional, and the court said it did not irrevocably adjudge a juvenile offender unfit for society. Rather, in line with concerns expressed in Graham, it gives the offender a, quote, meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation by permitting parole after the mandatory 20-year minimum prison term is served. Well, 87 years old, when Isaac gets to 2069 or 70, as the sentence plays out, we would submit as not a meaningful opportunity to obtain release showing maturity or rehabilitation. This is an end of his life sentence. And I think the case law that we cited, which this court cited in the Williams case, recognizes that there can be a virtual life sentence. Just because we don't add the phrase no possibility of parole does not make it that. This is really no possibility of parole. unless Isaac can beat the actuarial odds.
Mr. Nay, assuming we accept that premise, what is the U.S. Supreme Court's decision in Jones do to the mechanism for determining all of this? I mean, it seems to say so long as there is discretion in the sentencing court and youth is taken into account, that's constitutionally sufficient. Do we have that here? And I guess going back to the premise, am I misreading Jones?
Well, I think we have to take Jones for what it says. And Justice Kavanaugh was very clear that he was not changing the playing field, that Jones was not changing the playing field from Miller. And a quote from Jones that I think is significant is this one, in the majority opinion. It says, in Miller, the court mandated only that a sentencer follow a certain process, considering an offender's youth and attendant circumstances before imposing a life without parole sentence. Jones says it's not about complete incorrigibility. You don't have to prove that. That doesn't have to be established. But there has to be a certain process. That's Kavanaugh's language here. And two, that considers an offender's youth and attendant circumstances. So we need to read Jones with what it says.
Mr. May?
Yes.
Can I break that point and say, didn't that happen here to a certain extent when the judge basically made aggravated factor findings and enhanced his minimum sentence from 25 years to 40 years? Wasn't that sort of the functional equivalent of that? Or explain to me why that was different.
Well, we need to look at what happened here. And of course, this sentencing was pre-Miller. So I don't know, we can fault the judge for not doing Miller factors, but the whole sentencing was 12 pages long of transcript, which included the rights to appeal and the defense motion for an appeal bond. So there wasn't a lot of time spent on anything, let alone youth. His defense attorney doesn't even mention his age, in fact, but the judge in a passage, which I quote completely in our briefing, talks about age. But the problem is Judge Fleetwood, in a sense, used his youth as an aggravator, which seems stunning. And we have to look at this. He says, that night, there's evidence that Mr. Saiz went out that night to show himself a man, that he was one to be feared. There was a man to be dealt with. He was successful. I am afraid of him. Society should be afraid of him. I would submit that those attendant circumstances, which we now all recognize in youth, is kids, and that's what Isaac was, a 16-year-old kid trying to prove himself more than he was. So the judge is using that sort of chesting up, if you will, that, the bravado as an aggravator. But that's what teenagers do. That's what kids do. When we look at, and Judge Atchison, I know you were on the panel, the Williams case, and I know it's on review. But when we look at that, this court there said, you have to have something more than just a tip of the hat acknowledgement. And if you look at that, I think that, as I said, this is less than a page of transcript in the sentencing where the judge talks about youth at all. He doesn't really go into what the attendant circumstances are. He says, well, he's young, but here's the crime. Here's what he did. And that's enough. Well, Williams said that isn't enough. It's just not enough to acknowledge that. And if you compare these two cases, this is a drive-by shooting with one victim. Williams was a home invasion with two victims. But we're just not seeing anything. Is that enough? When Jones itself talks about a process where attendant youth and attendant circumstances are looked at, is this sort of, as I say, a tip of the hat? He's young, but he did a bad thing, and I'm scared of him.
Mr. Nay,
yes.
a quick question here. As I understand it, at the hearing, the sentencing hearing, all of the information concerning the youth came from the state, and in fact, the defense presented nothing at all concerning this. What else could the judge have done if the defense chose to essentially stand silent during sentencing?
Well, I mean, and we brought that out. As I said, the defense attorney didn't mention youth. I mean, the judge acknowledged that youth was a mitigating factor, a potential mitigating factor. We're not saying he didn't. But again, Miller and the progeny, including Jones, requires a process, requires something that goes deeper than that. You know, as the Williams case said, which is on review by the Supreme Court, there a child psychologist testified in Williams about the youth of the individual. But that, you know, the court is requiring something more where at least certain factors are being considered by the court. So
do you have any knowledge of why that wasn't presented? Now, I realize that we're talking pre-Miller here, but it almost sounds like this is a case of ineffective assistance in this, although that's not something you directly go after.
Well, and at this stage, while Miller is retroactive, I can't shoehorn the ineffectiveness in, but at least this court, I think, can consider it as part of this 1507, in that how much is the judge really considering, how much of a process is this under Miller and its progeny, if the defense attorney doesn't mention it at all. I certainly agree.
On a different topic, did you listen to or watch the tape of the Supreme Court argument in Miller? Williams. I'm sorry.
Yes, I did, Your Honor.
They seem genuinely befuddled as to what to do with Jones. Some saying that it changed the whole landscape, and others not being so sure about that. So,
well, yeah, and I saw the argument. Again, I'm not to criticize other counsel, but I think as we, in our reply brief, and of course, we wrote the opening brief in this before Jones. Right. We wrote the reply brief after Jones. And I think as our reply brief here in this case says, and what should have, in my opinion, should have been more forcefully argued to the Supreme Court, is look at the language of Jones. Justice Kavanaugh is not saying anything has changed. He is just saying you don't need the special finding of incorrigibility. But there still has to be, one, a process, and two, that process takes account of youth and attendant circumstances of youth. That's what didn't happen here, and I would argue it didn't happen in Williams, and that's, I think, what probably should have more forcefully been argued in the Williams case.
Let me shift gears a little bit again. Let's assume your premise is correct here about what Judge Fleetwood did, and that we find that there's error. Talk to me about how you envision a remedy here. And I mean, Williams was, to put it euphemistically, I guess, sort of circumspect about remedy. And you say, well, don't do what Williams did. It should be reversed and remanded. Describe for me what you think happens on remand.
I think on remand, this case, if this court finds error, this case goes back to the district court for a hearing, which the court has to hear from the defense, the circumstances, not just of youth. He was 16, as Williams said, just an acknowledgement of youth is not enough, but the attendant circumstances. You know, what kind of person is Isaac Saiz? Should he be locked up until 2070, basically? Or is there a middle ground here where the attendant circumstances of youth could mitigate this offense? Again, Judge Fleetwood talked about the age itself mitigating, but not the circumstances. And as I said, I think he used youth as an aggravator, that, you know, the bravado of youth to be an aggravator.
Well, and that's sort of the premise I'm accepting here. That's how we get to the error. Williams alluded to KSA 216620, which is the Alien fix. And this is not an Alien problem, but does that statute, by the way it's written, have any application on remand? I mean, are you looking at a jury process? Or is it simply a hearing to the court?
I think that's a good question, which we haven't addressed.
Well,
You're asking me
would
to
like your studied or not studied, your impromptu input on what we're supposed to say when we send it back.
Well, we know if Isaac were sentenced today under this case, there's another process in place. But under Alien, yes, he would get a jury in the pre-fix world to that issue. So I think that he would be given the rights that any defendant would get on a reversal, post, pre-Alien or before the fix was put in by the legislature. That's where I would come out. I think that's a question the district court would have to address. I would also argue in any event, even if we say that that's not afforded to Isaac, we certainly would get a full sentencing hearing where experts and whatever else the court would want to look at or the defense would want to put forward for the court would be allowed.
Mr. May, I see that you've used your 15 minutes. Actually, you've used over 15, but I'll still let you have your rebuttal. Are there any other questions from the panel before we hear from the state? All right. Seeing none, Mr. Gillette, I'll give you a generous 15 minutes. Let's put it that way.
Thank you, Your Honor. May it please the court. I think that there are a number of clarifications that need to be made here. And I think that the first one that is necessary is to understand that the sentence imposed in this case was absolutely a discretionary sentence. We can begin and end that question with Saiz 1, the defendant's direct appeal. Our Supreme Court evaluated the defendant's claim that there was an error in the district court's discretionary findings regarding the aggravating factors in this case that outweighed the defendant's youth and the attendant circumstances and found that there was no error. This is absolutely a discretionary sentencing scheme. That is all that Miller provides for, and Jones reinforces that simple reality. Jones, with all due respect, does not expand on Miller. It doesn't change the landscape at all. All that Jones does is make it absolutely clear that all that is required in order to even impose a life without parole sentence on juveniles is a process in which the district court may consider, can and will consider a defendant's youth and attendant circumstances. That's all. That's all that a defendant's that a juvenile defendant convicted of murder is entitled to. The defendant in this case got all of that consideration and more.
Well, you would agree that the consideration of youth in that context has to be as a mitigating factor, correct?
I think youth is generally is considered as a mitigating factor. Yes.
Okay. Well, I don't want to qualify. Yeah, generally under Miller, Montgomery, and Jones, it has to be considered as a mitigating factor, correct?
I believe that's what those cases stand for, that there are a number of considerations associated with youth that make it a mitigating factor.
Okay. How was Saiz accorded that in his sentencing hearing? How is youth used as a mitigating factor?
So the first thing my first answer to Your Honor is that if you read Jones carefully, youth does not have to be explained. The consideration of youth does not have to be explained on the record. Jones is explicit in that, because in its plain language, it says, if the sentencer has discretion to consider the youth or the defendant's youth, the sentencer necessarily, and this is emphasized in italics, will consider the defendant's youth. And it continues, as opposing counsel pointed out in their reply brief, that's especially true if a defense attorney points it out. I'm a little bit confused because I read the defense attorney in this case's argument as starting off by bringing the defendant's youth to the forefront. He says, quote, "May it please the court and counsel, Your Honor, on behalf of my client, I'm sorry."
I appreciate it. I read all of that, and I think you're begging my question here. My question is, what in Judge Fleetwood's very brief findings suggests that youth was considered as a mitigator, as opposed to an aggravating factor that, as Mr. Ney says? I mean, you look at it, and I think it's at least unclear. And I think there is a strong indicator that it, in fact, was an aggravating factor to the judge.
I suppose I would challenge this court to identify at what point youth was considered as an aggravating factor. Judge Fleetwood's ruling is pretty clear that he took into consideration the defendant's youth, and that even when doing so, there is absolutely nothing mitigating about it, because the defendant's behavior, his actions throughout this case, both the crime underlying it and getting through to the end, indicated that he was, for all intents and purposes, a man, acting as a grown man.
Well, I understand that's what he said, and that seems to undercut what we already established, though, is the rule of Miller, Montgomery, and Jones, that youth has to be considered as a mitigator, not a neutral, not an aggravator. It must be considered as a mitigator. And now you're saying, well, Fleetwood didn't, he looked at it, but he didn't see it as mitigating in any way.
That's because he has the discretion to evaluate the weight of that mitigating factor. And there was no weight to that youth as a mitigating factor here. He was clear that he was considering the only statutorily defined mitigating circumstance that exists is the age of the defendant. And then he continued to evaluate the weight.
Well,
of that
I understand that, but we're not dealing with the statutory requirements. We're dealing with a constitutional mandate under the Eighth Amendment.
And all the Eighth Amendment requires is the discretion to make the consideration. It requires no on the record explanation as to how the court evaluated that factor. And here we are in a better circumstance back in 1999 in Kansas under Kansas law than they were in the Jones case and the Miller cases. It's just by happenstance that our statutes at the time provided all of the discretion that's required under the Eighth Amendment, and the entirety of the process to which a juvenile defendant convicted of murder is entitled to at sentencing.
As long as I started down this line, let me play it out. And again, assume at this point that we, or at least I, accept the premise that Mr. Ney is making, that there was an error here, and the case is sent back. What do you envision as a remedy in that circumstance? I mean, what are we supposed to do? Or what's supposed to happen in the district court on remand? Right.
And I will not concede error in this case, to be perfectly clear.
I'm not asking.
I understand you understand that, but I think that the appropriate remedy here, as we identify in our brief, would just simply be a hearing before a district court to evaluate the constitutional harmless of any error. If we were to presume some error here, it would be a hearing to evaluate constitutional harmlessness, or frankly, this court could do it. It makes no difference.
Well, what would that look like? I mean, what do we look at to see if it's constitutionally harmless? Would it come out the same way anyhow? Basically. Okay, does that require then looking at the various factors and whatever other like expert evidence there could be presented and stuff? I mean, do you wind up with a full-blown sentencing hearing to evaluate that?
No, We sentence based on the law in effect at the time the defendant's crime was committed and when he was sentenced. The law at that time is clear. Nothing about the subsequent cases, Miller, Montgomery, and Jones, change or render anything about the sentencing process and procedures that were applied here constitutionally deficient. And I think that alone resolves this question. Even if we were to assume some error, it has to be deemed harmless beyond a reasonable doubt. And I think, this brings me to a point that I want to bring up, in that I'm not asking this court to do anything differently than it did in Redmond or what this court has done in its previous cases. Williams is aberrant under Kansas law. I'm asking this court to apply Miller as explained in Jones. Miller's only applicable to mandatory life without parole sentences. Neither of those two things exist here. There is no life without parole sentence. There's absolutely nothing mandatory about this. To Judge Atchison, to a number of your questions, expanding Miller judicially to apply to some kind of a term of years or this ethereal de facto or functional equivalent is both confusing and leads to rampant uncertainty. I heard opposing counsel today take differing positions. At one point, he says the defendant could live to the age of 87 and beyond. And then later he's talking about actuarial odds. Maybe he will, maybe he won't. We're talking about a test that is not appropriately defined under a case such as this, where an issue is raised, decades later, and where we're talking about what is basically substituting this court's judgment for that of a district court. And I think I make it clear in that brief, that's what the defendant is asking for in this case. And that is not appropriate.
Mr. Gillette, are we going to know what the legal landscape is before our Supreme Court decides Williams? Is there any way? I mean, you say it's an aberration. Well, let's suppose they embrace it as the way of the future. Don't we have to wait and take a look at that?
You could, but the fact that we're here today suggests that you may not. And I would suggest that when I watch and I observe the argument in Williams, I would point this court to Justice Rosen's questions. I think it's pretty clear. Jones answers the question here. This court said in Redmond that you didn't want to start lurching towards some kind of wishy-washy test and how we evaluate youth and things until there was subsequent guidance from the United States Supreme Court. Jones is that guidance. Jones controls. And all that Jones requires is the discretionary procedure and opportunity for the district court where it is required to evaluate youth and its attendant circumstances. That happened here. And to that, I'd say, even if we assume that there were to be some need to expand Miller to whatever this ethereal test or hypothetical guessing game proposed by opposing counsel would be, this defendant, again, he got all of the discretionary consideration he was due and more. I point out in my brief one thing that I think is important to consider at the beginning. Our motion for adult prosecution statute is much different than those that were evaluated in Miller, and then there was the Arkansas statute that I cite in my brief as well. Defendants in Kansas, when they're juveniles, they get much, much more protection, and where district courts are required to evaluate youth and its attendant circumstances. Moreover, here, it is definitively clear that this court did just that. Judge Fleetwood heard the map in the preliminary hearing, he heard the trial, and he conducted the sentencing. I think that explains why defense counsel's statements and arguments at trial or at sentencing are as brief as they were. There's nothing more to prove or show to Judge Fleetwood. He was abundantly aware of the defendant's youth and his attendant circumstances from the word go. I would also note that not only is the defendant's hard 40 sentence absolutely the result of an exercise of indiscretion, His aggregate sentence is also an absolute exercise of discretion. It is plain that the district court has unfettered discretion to impose a consecutive sentence for multiple charges in a multiple conviction case. The district court did that here because the defendant's actions were so egregious. He killed an 8-year-old child in a drive-by and he tried to kill 2 rival gang members. Those are egregious facts, and egregious facts lead to substantial sentences. I'm just taking a quick look at my notes. If your honors beg just a moment here. I heard another phrase in opposing counsel's argument, the Miller factors. I don't know what those are. There are no Miller factors. Miller does not set forth any kind of A, B, C, X, Y, Z test. Jones makes that clear. All that is required is the district court's mandatory consideration of youth and his attendant circumstances. And again, the district court did that here. That was the attendant circumstance, the mitigating factor that was both noted and considered by this court and rejected because it had no weight. The other thing I guess I just would finally mention is that I've also heard that now we're going to start trying to drift and bring this into the realm of ineffective assistance of counsel. That is not an issue that's before this court. And I would urge this court to not consider that. Again, it's clear that the defense attorney in this case who represented the defendant made sure that the court knew the defendant was a child. He was 16. Nevertheless, that simple fact and its attendant circumstances meant nothing. It had no weight. And that's the ultimate answer here.
Well, except that all of that is decided pre-Graham and Roper, which recognize that there is something more than just chronological age at play when you're dealing with a juvenile offender, right?
That is, but youth and its attendant circumstances, youth in general, I think that what we need to be clear about is when we say youth, we're not talking about just chronological age. The word youth encompasses an age and the attendant circumstances. That's what youth is.
Well, I understand that. And Roper and Graham elaborated on, as a constitutional matter, what those circumstances are. And nobody in this case at the sentencing had the benefit of that insight or very likely the science behind it, right?
I would respectfully disagree. And I think that the four factors you're talking about are retribution, deterrence, incapacitation.
No, those are the policies that guide punishment regardless. And I'm talking more about the recognition that brain maturation typically doesn't occur until the late teens or early 20s, that juveniles are given to impulsive behavior more than adults are, and that those are factors that should be taken into account in fashioning what would be a constitutionally appropriate sentence for a juvenile offender, recognizing that in some circumstances it can lead to life without parole, but it has to be a studied determination. And what I'm saying is in 1999, when he was sentenced, not only was that not articulated as the law, I'm not even sure that that science was widely known. So it could not have been considered at the time. And you're saying, well, that doesn't matter. And it seems to me it at least matters in some manner. You can't just dismiss it and say it doesn't matter.
Your Honor, respectfully, I don't know where Your Honor is getting the phrase a studied determination. That does not exist in the Eighth Amendment. It does not exist in United States Supreme Court case law. All that is required under Jones, which is reinforcing Miller, is the opportunity to consider youth and that it be considered. Now,
well,
there's no requirement for degrees of consideration. There is no requirement for an explanation of how a district court considered it. That remains true today, even if we are to assume many of the things that Your Honor just mentioned. there is no requirement for whatever a studied determination would be. That just doesn't exist under constitutional law. To that same end, when I hear opposing counsel talk about bravado and this is just what kids do, respectfully, that makes no sense. Kids do not generally go out and commit homicides and multiple attempted murders, and after the fact brag about it to their friends, and later in habeas proceedings before the federal courts claim that this is all just a big accident. This is not youthful bravado. This was a defendant that was mature. He made intentional decisions, premeditated decisions, and he acted upon those premeditated decisions, and an 8-year-old's dead because of it.
Well, thank you very much. I think
Thank you.
used up all your time. Any more questions from the panel?
No.
Very well.
Thank you.
Mr. Nay, you have 3 minutes.
Thank you, Your Honor. Judge Fleetwood clearly did not consider attendant circumstances. His last 2 sentences in relation to sentencing here, as far as youth is concerned, he said talking about Isaac, he did not consider himself a child at that time. He desired to be viewed and treated as a man because he committed an adult crime. So that would negate any kind of consideration of youth. The state talks about attendant circumstances. Show me here where attendant circumstances were considered other than a chronological age. That's it. That's the only thing that was talked about, not immaturity. The state here just argued, well, Isaac Saiz was mature. How do we know that? Where is anything in the record that shows that? This was a shooting. Group of guys shoot, and Isaac was there, shot at a car. A bullet, unintended, hit an 8-year-old in a house. So I understand the facts. When he talks about that it wasn't intended, this wasn't intended. This was a reckless, immature, ridiculous act that ended up in tragedy. We agree this is a tragedy. The state's initial effort here was to prosecute both under a theory of premeditated and felony murder. So even they were not convinced that this was a deliberate act that took the 8-year-old's life. And we just would submit here that when we're looking at this case under these circumstances, we have to look at whether anything besides a chronological age was mentioned, and it wasn't. And when it was mentioned, it was used as an aggravator. Just like saying in a capital case, for example, if a defense puts on a mental disease as a mitigator, the prosecutor cannot legitimately use it as an aggravator to say that now you've got a crazy person, that's why you should kill him. So much like here, that's what the court did. Thank you, Your Honor.
Thank you very much, counsel. We appreciate your excellent arguments today. We will take this matter under advisement and render a decision as soon as we're able. Thank you all.
Thank you.